What happens if two different persons made the same invention independently of each other? Who has the right to patent the invention? The principle of first to file establishes that the right to a patent belongs to the person whose application has the earliest date of filing. So the date of filing is important, not the day in which the invention was conceived. Europe always adopted the principle of first to file. On the contrary, Canada, United States and the Philippines were among the only countries to adopt the principle of first to invent, which establishes that the invention belongs to the person who first made the invention. The principle of first to file is much simpler in case of a dispute, while establishing the date in which the invention was conceived can be very complicated. The United States adopted the first to file principle in 2013 with the America Invents Act. Also, Canada and the Philippines switched to the first to file principle some years ago. In the United States, Canada, Australia and Japan, you can disclose your invention before filing a patent application without destroying its novelty. You have a so-called grace period to file your patent application after you have disclosed it. Such a grace period lasts 6 months in Japan and 12 months in Canada, United States and Australia. For instance, you can publish an article on a journal describing your invention and subsequently, within the grace period, you can file a US patent application to protect your invention in the United States. However, if you file a patent application in Europe, it would be refused for lack of novelty. For the presence of such a grace period, some define these patent systems as applying the first to disclose rather than the first to file principle. A patent is a territorial title valid within a single nation. You may file your patent application, for instance, in Italy, and after some time you may decide that you also want a patent in France and make a new filing in France. However, if you do not keep your invention secret in this period between the two filings, your patent application in France will not be considered new. Furthermore, someone else may have filed in France a patent application for the same invention after your Italian filing, but before your French filing, therefore being entitled to the patent in France on the basis of the first to file principle. So there is a need to have a period in which you can extend your patent application to another nation, claiming priority from the first filing, which means that your new application will be considered as having the date of filing of the first application for what concerns the state of the art for the evaluation of novelty and inventive step. The priority principle was established for the first time in 1883 with the Paris Convention. For a patent application, the right of priority is 12 months. This means that you can make an invention, file a first patent application, for instance in Italy, disclose your invention by selling it or showing it in an exhibition, and within 12 months from the first filing, file a second patent application abroad or a European patent application or an international patent application in respect of the same invention, claiming priority from the first Italian filing. The disclosure made in the period in between the two filings will not be considered for the evaluation of novelty and inventive step. Also, the filing of the same invention by a competitor in between the two filings will not affect your right to the patent. But if a new part, for instance an improvement, is added in a second filing to the original invention, the new part will not enjoy the right of priority.